Good evening. Thank you for joining our estate planning webinar. My name is Paul Lindsay and I am one of the estate planners here at MacMillan Estate Planning. So the plan today is to spend approximately 40 minutes covering off the essential components of a comprehensive estate plan to give you all a flavour of both our business and some of the solutions that we can look to implement for you and your families. Many of the families that we've been speaking with of late are becoming increasingly worried about the future. Understandably, they are anxious about COVID-19 and the risks that it poses to them and their loved ones, but they could also be worried about many other issues, both globally and closer to home. Thankfully, many of the families that we work with tell us that we actually make them feel a little bit better, providing them with a sense of peace of mind and empowerment. Not because we've solved all of the world's issues for them, and far from it, but they feel better because we give them the strategies that they can use to protect themselves from a wealth preservation and legacy planning perspective. We want to give them the ability to control a portion of their lives, irrespective of what the future brings. As part of our planning process, we spend a considerable amount of time educating our families about the options available to them that can help to protect their estate from a number of risks, like family-related issues, market volatility and undue tax. And I'm going to deal with some of those options at a broad level with you this evening. If you have any further questions surrounding the design of your bespoke estate plan, I would encourage you to take advantage of a complimentary consultation with me or one of my colleagues. During the initial session with you, we'll explore the issues, gather information that will allow us to provide you with a number of recommendations based upon your concerns and your needs. Indeed, there will be a link provided at the end of this presentation so that you can request a complimentary consultation. Now, not only will you be able to come and meet with me or one of my colleagues, but you will also be entered into our prize draw to have the chance to win a fully paid 12-month sponsorship of an orphan baby elephant from the Sheldrick Wildlife Trust, which is a charity that our CEO, Sherry, holds very dear. So, before we get into some of the key elements of a comprehensive estate plan, I just wanted to share a little bit about our firm. Now, MacMillan Estate Planning was founded nearly a quarter of a century ago by our president and CEO, Sherry MacMillan. And it came to be as the result of an experience that Sherry had whilst working at one of the big banks. Sherry found that the bank was placing its own interests ahead of the interests of their clients. And this didn't sit very well with Sherry. And so soon afterwards, MacMillan Estate Planning was born. We service an extensive geographical area. Currently we're operating throughout Western Canada, the United States and the United Kingdom. MacMillan Estate Planning has provided our clients with virtual estate planning services for over a decade. We have all the people, processes and technology in place to meet almost every essential estate planning need without actually having to step into one of our physical offices. As I turn to the next slide, you will see a list of professional designations. Now here we have professionals accredited and affiliated with all of these designations here in-house, and that allows us to provide a truly comprehensive estate planning service. At the end of the day, our lives have become very complex. Our families are often now spread out throughout the world, and perhaps we own different assets in different provinces and countries. Those dynamics create opportunity, but in some instances they also create restriction. So that's why it's important that we have a group here of professionals that can come together and look at your needs from a multidisciplinary perspective, so we can make sure that every aspect of your planning can be addressed. So, taking that concept of a multidisciplinary team just one step further, on this next slide what you'll see are the two approaches to estate planning. There's the compliance or the traditional approach, and we pit that against the more strategic approach. The traditional approach is the one where you'll find yourself meeting with one professional at a time. One day you'll be at your lawyer's office explaining to them what you think you need. The next you could be with your accountant, the following with your investment advisor, and so on. then you've got the unenviable task of reconciling any conflicting advice and pulling it all together and putting it into some sort of estate plan. Now, the strategic approach that we use involves all of those services being made available at one location. Acting like your architect, as estate planners, we're looking to join the dots between all of the disciplines, bringing all the expertise and ideas to you. A simple example to show how our approach to estate planning is beneficial is when we look at the common practice of perhaps putting a child on the title of a main residence or a family cottage. Often that's with the aim of avoiding the costs and delays associated with probate. A lawyer will usually comply with a client's request to do this and complete for them what is a fairly simple transaction. The difficulty is that sometimes the lawyer is only thinking about this from a legal perspective. Now, if we assume that the property we're talking about here is your main residence, we've now got a deemed disposition of that for tax purposes. Whilst you can get the appropriate main residence tax exemption, don't forget your child has now taken that property at a zero cost base. And so in the future, when they dispose of it, it's likely that they will incur taxes. So instead of having an asset that should be growing tax-free in your estate, and which can be passed to your children upon your passing without any tax, what we've done is we've now created a taxable event just by doing that transaction during your lifetime. Stay with this example, if you will. It isn't just the tax aspect that could prove an issue. Now imagine you're in the scenario where you want to sell the house. In that situation, you're going to need the permission of your children to complete that transfer because they're the legal owner. What if your child is suddenly facing a divorce? You could find that their ex-spouse is now claiming that your residence is matrimonial property and that they're entitled to a share of it. We can also consider what could happen if, after the transfer, your relationship with your child breaks down for some reason. So it's incredibly important to be able to join the dots and really reconcile the advice that you get from all of your advisory team. And having them all under the same roof really does help to do this. So your full service team here at MacMillan is comprised of not only the professionals, but more importantly you and your family. Because the expectations of your family and other beneficiaries is something that we pay particular attention to when we build your estate plan. And we call it the now infamous Christmas dinner question. We ask every family that we work with that question. If your family knew what your estate plan looked like, would they still come home every year for Christmas dinner? Ultimately, it is not unreasonable for your children, usually, to have some expectation of inheriting from you, and so you've got to be mindful of these expectations and have made a reasoned decision concerning how they will be managed. In our view, communication is the essential ingredient when it comes to preserving that family harmony. So why create an estate plan? And of course, this is the big question here. Now, before we go into some of the elements of a comprehensive estate plan and some of those strategies that I talked about earlier, I want to briefly look at the reasons why families create an estate plan. Now, here in Canada, approximately 50% of individuals don't have a will. And I would suspect that the percentage of people who don't have comprehensive estate planning is significantly less than that. Creating an estate plan is all about taking control, making sure that your objectives and your goals for the future can be met. In our view, once you have an estate valued in excess of $1 million, you need more than the traditional basic will planning. And even in these uncertain social and economic times, how can we empower ourselves through our planning? Well, the answer really lies in finding ways to minimise tax, preserve our wealth, protect our bloodline, and ensure family harmony. I'm afraid to say that tax is a reality you can't get away from completely, but there are ways that we can be smart about it. And at MacMillan, we help you to minimise the tax impact, which could include looking at capital gains planning, which might involve discussions about your principal residence, as well as the other exemptions and mitigation opportunities available to you. Now, in terms of how we might preserve wealth, there are opportunities to protect the value of your investments so that we ensure that the principal value is guaranteed, safeguarded if you will, against losses during a market downturn. Because this is key to maintaining your standard of living through retirement, which, given that we're now part of an ageing population, could actually be a period that is longer than your working life. Then bloodline protection relates to the means by which we can protect your estate for your bloodline. We ensure that it can't be lost to external forces, like a divorce, bankruptcy, litigation, or maybe if your spouse forms a new relationship after your passing. Then family harmony comes in and wraps everything together. And when we talk about this family harmony point, what we're actually trying to do is make sure that when you die, you minimise the risk of any litigation or infighting between the family, because for those of you who have ever been involved in estate litigation or know someone that has, you'll probably know that it is not a pleasant time and it can involve great stress and significant cost as well. So now that we've covered a little bit about our firm, the importance of a comprehensive approach to estate planning and the reasons to plan, I now want to turn to the most important component of any estate plan, and that's you, your family, and your significance. The way that we see your significance is that it's what's most important to you today, and protecting it will be a moving target throughout your life. What is significant right now could change and evolve as your life unfolds. In your younger years, your significance may well be your family. Later, it could be more focused on your career or business. And in retirement, it could be enjoying the spoils of your labour by travelling, engaging in charitable work, or just being able to spend more time with your loved ones. But the point is this: your significance matters, and you deserve the right to safeguard it for the benefit of you and your family. Now we're really getting into the part of our presentation when we're going to look at the different components of a comprehensive estate plan, as well as touch on some of the more relevant strategies available to families. What is a strong room? Well, as some of you may know, forgive the history lesson here, but historically a strong room was a fortified room in a castle or stately home of a noble family during the Middle Ages. These families would store things like jewellery, money, land titles and other important documents in their strong room so that they would be protected from attack by any external forces. We see your estate plan in the same way, that the strategies that we use, using those tools available to us as practitioners, provide you and your family with your very own strong room as a mechanism for protecting your estate. We build that strong room to safeguard this significance, which sits at the very centre of your planning. The different facets of the plan surround and protect your significance, all of them working in harmony together. Your life plan, well, that's going to be the driving force of your estate plan, and so we usually start by implementing this particular plan so that we can ensure that your significance is protected, preserved, and so that your estate can be enjoyed during your lifetime. I think we have to be cognizant of the fact that you've built this estate, and so it's far from unreasonable for your goals and needs to be paramount. Once that's been completed, we turn our attention to your legacy plan, and if we've done the life planning properly, your legacy plan should naturally flow from it. The legal plan and the tax plan are essentially the technical tools that we use to enforce your life and legacy plans. They are there to help support and inform your objectives, but not necessarily to define them. These technical elements all working together effectively is, as I've mentioned, very, very important. A legal plan will typically consist of a will, power of attorney, a personal or health directive, and some trust planning. Now, whilst the very phrase COVID-19 has only recently become a part of our day-to-day vocabulary, in our experience it has certainly made a lot of our clients and families look at their mortality in a little bit more detail. Now, I suspect that many of you will be familiar with the operation and effect of a will, namely that it simply determines how your estate will be administered after your death. Now, you can decide who will act as your executors and trustees, the amount or subject of any particular legacies, and then how and to whom the remaining assets pass. Now, very briefly as an aside, it's worth reminding you that in the unlikely event that you don't have a will, then it's the government who decide how your estate will be administered, and this then, I suppose, removes the choice from you and could give rise to a distribution that really doesn't match up with your wishes. As I've mentioned already, in our experience, once your net worth exceeds $1 million, you have arguably outgrown that simple will, and you need to be looking at something to give a bit more additional protection. With the uncertainty that remains as a result of the global pandemic, it really is important to have clarity and peace of mind wherever you can, and a power of attorney and personal or health directive can certainly be of assistance in this area. A power of attorney allows you to appoint an attorney to manage your property and financial affairs in the event that you should lose capacity to do so during your lifetime. Whilst we hope that the document will never ever see the light of day and that you will always be capable of managing your estate, it really is important, certainly within your estate plan, because indeed, if you lose capacity without having executed this document, typically it would be your family that would have to make a lengthy and costly application to court to get the required authority to manage your estate. Then we have a personal directive, which is often referred to as a health directive, a representation agreement, or a living will. And this is a document that allows you to appoint what is known as an agent to make decisions about your health and well-being if you lose capacity. Customarily, this includes decisions about end-of-life care and equally in terms of life-sustaining treatment. It's pretty bleak, but it gives invaluable guidance to family members and healthcare professionals, and we've got to bear in mind that the documents are often being utilised in unexpected situations, and so again, this is really a significant component of your legal planning. I have to say that historically I've always told clients to think of these powers of attorney and personal directives as being like insurance policies. None of us really want to pay the premium, but we're really glad that we do if we ever need to make a claim. And the same is true with these documents. They give significant reassurance for families at what is often an emotional and stressful time. And that brings us to our next topic within the legal plan, which is perhaps less well known, and that is trust planning. Essentially, a trust is a legal relationship whereby trustees hold assets that they manage on behalf of a beneficiary or beneficiaries. Another very brief history lesson. The history of trusts spans back to the 1200s and the Crusades in Europe, and since then they've been used as an effective tool to control the passing of assets to beneficiaries, and also as a means of safeguarding those assets generally. Trusts can be created during your lifetime when they're known as inter vivos trusts, or they can take effect upon your death when we refer to them as a testamentary trust. To illustrate the use and benefit of trusts a little more, I'd like to tell you a story about a family that we've been involved with recently who've built a substantial estate but want to limit their children's access to the family wealth because they're concerned about not only the dreaded son or daughter-in-law from hell, but more so the impact that their wealth could have on the children's outlook on life and the development of their work ethic. They don't want them to just become trust fund babies. And we've recommended what is known as an incentive trust. The incentive being that if the kids, in this case, get out of bed each day and go to school, then find jobs, the trust fund will be there to support them without actually enabling them to just sort of rely on the fund. In fact, it's been proposed that the trust will allow the children to take an income to an equivalent value of their own personal income. Now, as a slight aside, we can include non-financial factors as well, but as you'll see, herein lies the incentive for the children to succeed. If they do nothing and earn nothing, well, they get nothing from the trust. Now, trust structures are really useful as well for parents of children who have, say, health conditions, which mean that they couldn't manage any direct provision made for them from the estate. It means that a disabled child can still benefit even though there are controls in place to dictate how this is done. With this kind of planning, we'll ensure that an inheritance doesn't adversely affect their entitlement to any government programs. Now, we also come across instances where a child has perhaps, or rather a client has a child who has issues with alcohol or substances. And so if we give them a direct benefit from the estate, it could do more harm than good because it will just compound their addiction, potentially with catastrophic circumstances. So a child or beneficiary in this situation, whilst we hope they'll be able to turn their lives around, the estate plan in that instance can simply be amended to reflect this, but we put some controls in place. It's also common for trusts to be used within the blended family, in which we have spouses who've been married before and they both have children from those prior relationships. In that scenario, trusts allow clients to discharge their legal and moral obligations towards the new spouse, if you will, during their lifetime, but ultimately ensuring that their estate, the capital, passes to their children. A number of our wealthier clients who are aged 65 years or over are often creating a particular type of trust called a joint spousal or alter ego trust. Here at MacMillan, we term this particular trust the Secure 65, because this kind of trust protects underlying assets from creditor claims, as well as providing complete privacy for a family in terms of the ability of a third party to find out about the nature and extent of their assets. What I mean by this is that if assets are not held in a trust and go through probate, then any third parties are entitled to make inquiries of the court and obtain documentation which will provide them with an itemised account of your estate and a copy of your will. The Secure 65 Trust provides for enhanced administrative efficiency as well. When you die, the assets held by the trust aren't subject to probate, which in many provinces means that there's an opportunity to save on some significant probate fees. At the same time, it's a lot harder to challenge a trust compared to an estate. And finally, unlike other inter vivos trusts, there is no tax paid when assets are rolled into the trust. The next component of the strong room approach is life planning. Now, a life plan is about giving definition to what you want from your life going forward. In its purest form, it's a bucket list of all the things you want to achieve and how you plan to make them a reality. Good estate planning should focus on your life, which is, understandably, why we make it the main facet of your strong room. As I mentioned already perhaps, people today are living longer than ever before. At the moment, in Canada, there are over 48,000 people aged 100 or over. That number is growing. It's also the first time in mankind's history that there will be more people over the age of 65 than under. And if you're one of those fortunate people who gets to be 100 or more, you've got to make sure that market volatility, tax, health, and the costs of care in our latter years are properly accounted for so that you're protected for the decades ahead. Now, here on this slide, we look at asset and investment protection, private and principal guarantees, and business succession. So, first off, asset and investment protection. Well, assets and investments should ultimately supply families with a concrete source of income for retirement. Unnecessary loss because of tax, market fluctuation, or other external forces like a divorce, bankruptcy, or a lawsuit can be avoided if the correct precautions are taken. In terms of business succession, remarkably, 70% of all family-owned business in Canada fails to properly succeed to the next generation. So, to ensure your company's future and avoid unnecessary complications, you really have to make sure you get an effective business exit plan in place. And last but by no means least, we've got this idea of a principal guarantee, and what this means is that you can have peace of mind knowing that the value of your investments is protected and guaranteed regardless of what might happen in stock markets during your retirement years. On this next slide, you'll actually see a principal guaranteed investment in action. And I would ask you to look and see, well, okay, at year one at the bottom, our client invested $100,000. Her investment grew from year one to year five to $140,000. Throughout the intervening period, our client has been activating resets or locking in the gains, which are represented by the circles. In year three, the value is $110,000, year four, $130,000, and finally, in year five, we see the value at $140,000. Unfortunately, during year 6, the pandemic began, which decreased the value of the investment back from $140,000 to the initial $100,000 value. Now, that shaded area spanning the period from year 5 to 10 shows a decrease in the market value. However, irrespective of that, our client's principal is protected at the high amount of $140,000 because of the principal guarantee. For the purposes of this slide, we've assumed the client dies in year 10, represented by the darker circle. The client's estate doesn't get the market value of the investment, which is $120,000, but it will actually receive the highest locked-in amount, which was $140,000. Assuming that in year 11, when the estate has transitioned to the beneficiaries, markets improve, the investment continues to grow, well, the new owner can do exactly the same as the initial investor and lock in the higher amounts, again protecting the principal and giving peace of mind perhaps for their own retirement. Okay, so moving on to the third component, and that is your tax plan. Your tax plan is an important technical tool that's used to protect your life and legacy plans, and it shouldn't necessarily control your planning, but it will definitely support your goals and objectives. Every year, countless individuals are paying an excessive amount to Canada Revenue Agency. As I've said, because paying taxes is an unavoidable reality, even in a well-designed estate, using the right tools and knowledge can significantly reduce or even defer this sum. And a proper tax plan really has to account for both domestic and international taxation. A lot of families are unaware that internationally held assets, like a property or investment in the US, are liable to both US and Canadian taxes. And failure to structure these assets within a larger tax scheme will inevitably cause their real value to be reduced. Foreign assets, by their very nature, can also legally create multiple estates. So if you own property in the US or anywhere else, you have both an American and Canadian estate. When you die, these two estates will have to be settled, and that considerably adds to the amount of time and cost required to do so. Tax minimisation generally can be as simple as us looking at an RSP withering strategy so that you know which accounts and assets will be utilised to produce your retirement income first off, and how that will in turn save you some tax. Another aspect I'd like to share with you is this idea of an estate freeze. Now, an estate freeze is an advanced asset protection strategy whereby a business owner looks to defer capital gains tax on a portion of their business's value by freezing its present value and then allowing others, usually family members, to share in the future growth, deferring the tax liability to them at the same time. And this is done by reorganising the existing share structure and commonly in conjunction with the use of a family trust. From an estate planning perspective, by using an estate freeze, you then quantify the tax that's going to occur on the passing of the business owner. And this can have a number of benefits, in fact, because if we know what the tax liability is going to be when the business owner dies, we can put a plan into place to ensure that those taxes are paid without destroying or disrupting the business. And at the same time, there's an opportunity to eliminate or reduce that liability over the business owner's lifetime. And that, of course, reduces the tax owed even further. Finally, an estate freeze can also significantly enhance your business succession plan because it gives your successors the opportunity to get, well, I suppose you'd term it some skin in the game, because they can see that any growth or future value is being attributed to them. And that helps to strengthen their ongoing participation in the business, all while the current or the initial business owner retains control. So the fourth aspect of your strong room is your legacy plan. And this plan should transfer your vision, wisdom and belief systems to the next generation, ensuring that your legacy can resonate and endure. At MacMillan, we look at your legacy plan this way. If you think you've got 2 kids, you've actually got 3, and that third child's name is Canada Revenue Agency. If you've got assets outside Canada, you might have 4, maybe we're adding the IRS to that list as well. So what do? You've got these two insatiable kids who are always wanting more from you. Well, you could send them away for adoption, but how can you do that? Well, that's done by replacing them with a charity of your choice. Because normally, up to 75% of a taxpayer's net annual income can be claimed as eligible charitable donations. In the year of death, that goes up to 100% of your net income, and it creates a substantial tax saving opportunity, while also allowing you to support your charity of choice or begin a legacy by creating a charity or bursary programme. If the donation is large enough to eliminate all tax, there's also an option to carry the credits back up to 1 year prior to death, which creates additional tax savings. In addition to the charitable giving point, your legacy plan should account for estate administration and probate as well. On average, the probate or estate administration process can take 12 to 18 months, but depending on your particular estate or if there's litigation, we've seen the administration of estates take many years to resolve. And don't forget, whilst the estate's being administered, the assets are frozen. And so the ability of your representatives to take steps to react to market volatility during the period are effective. But there are a number of strategies that can help with this. It could be as simple as having designated beneficiaries on life insurance policies, TFSAs and RSPs. And also, as we touched on earlier in the presentation, trusts can also help bypass that probate process. So we have discussed a lot of concepts this evening at a very high level. Many of these concepts and ideas presented may not be suitable in your own unique circumstances. And so that is why we offer potential clients a complimentary consultation. So you can sit down with a qualified planner and ask questions about your life, legacy, legal or tax plans and get answers that are a bit more specific to you and your family. Now, with that, I will sort of look to bring the presentation to a close, but I will also be sharing the link to the form so you can request a consultation with one of our planners. And also just a gentle reminder that by filling out the form, you will have the chance to win a fully paid 12-month sponsorship of an orphan baby elephant via the David Sheldrick Wildlife Trust. It's a great gift where you get lots of updates, pictures and videos of your very own baby elephant as it grows up on the reserve, and my family have sponsored a few recently and our kids just love it. It's a good little gift to pass on to the kids or grandkids, and you also don't have to keep a full-grown elephant in your garden either. Just one final point, and that is to say that if you have received a seminar response card and you'd like to fill it out and give us a little bit of information prior to any consultation, we would certainly welcome that, although there is, of course, no pressure there. And with that, I will end the presentation today. Thank you again for taking the time to join us.